I'll start.
Yeah,
Okay.
Mahalakshmi.
A warm afternoon to everyone present with us here today. With another new day, VESIT's Institution Innovation Council, in association with VRC and VESIT's IQAC, bring to you another informative session on Introduction to IPR and Patent Filing Procedure. I'm sure at some point in all our lives, we have struggled to understand the rules, the patent filing procedures, and broke our heads on it trying to Google for the most appropriate information. But the confusion quite ends here. I, Mahalakshmi Pendyala, take immense pleasure in welcoming all of you today to this session with the scholar of our own field, Mrs. Parvathy S. Before we begin the session, I would like to call upon Dr. Nadir Charnia, sir, to address the gathering with a small welcome note. Over to you, sir.
Thank you, Mahalakshmi. Am I audible?
Yes, sir. You're audible.
Okay. Respected Principal, Vice Principal, Heads of Department, Deputy Heads, dear faculty members, and dear students. On behalf of VESIT, I welcome you all for the session on Introduction to IPR and Patent Filing Procedure. Our nation is commemorating the 75th anniversary of India's independence under the banner of Azadi Ka Amrit Mahotsav. Under this banner, Department of Promotion of Industry and Internal Trades, Government of India has launched the National Intellectual Property Mission, that is known as NIPAM. The Pan-India ambitious mission aims to provide awareness of intellectual properties such as patent, designs, trademarks, copyright, and geographical indications. We have with us a very eminent expert, Mrs. Parvathy S. from Indian Patent Office, Mumbai. She has a vast experience in the domain of IPR. The agenda of the session is Introduction to IPR, Patentability Criteria, Filing Procedure, Timelines, Formal and Technical Representation of Patent Application. This awareness program being conducted by VESIT IIC in association with VRC and IQAC will inspire students and faculty to innovate and protect their creations. Thank you. Thank you all.
Thank you, sir. And as for our guest speaker for today, we have the grateful opportunity of having with us Mrs. Parvathy S. With a master's in philosophy degree and master's of science in biochemistry from the University of Kerala, Mrs. Parvathy is currently an assistant controller of patents and design at the Intellectual Property Office in the Department for Promotion and Industry and Internal Trade. She has also been the examiner of patents and designs from the years 2012 to 2019. Throughout her journey, she has examined and analyzed innumerable patent applications in various fields across biotechnology, biochemistry, and food technology. We are extremely humbled to have you among us, ma'am. I'm sure all of us are looking forward to gaining knowledge and imparting that in our own educational journey. With that, let me take this opportunity to invite our guest speaker, Mrs. Parvathy S. Before I hand over the flow of this event, I request all the participants to kindly mute yourself whilst the event to avoid any unforeseen disturbance. Any queries and questions are to be put in the chat box for a question and answer session towards the end of this event. Over to you, Parvathy, ma'am.
Thank you. Thank you, Mahalakshmi. That was a really great introduction, and I like it. And this is an awareness program conducting by a National Intellectual Property Awareness Mission by Government of India to make the students and the faculties and those who are doing research to be aware about their intellectual property rights. For the students and researchers, it is mostly about patents, and for in general, everyone regarding the various intellectual property rights and how to protect them. Am I audible?
Yes, ma'am, you're audible.
Okay, that's great. In this session, I had talked with Nadir sir regarding this awareness when the request had come. Generally, for the awareness program, we provide the introductory session. Is it echoing? Or is it just okay?
It's fine, madam.
Okay. So, in general awareness, we give an introductory session regarding all the intellectual property rights like patents, copyrights, trademarks, designs, geographical indications, and all. So when I talked with Nadir sir, he only informed me that you students are aware of such basic intellectual property rights, and like general introduction, you already had some sessions. Maybe you are having intellectual property rights in your syllabus or as a part of your academics. So in this session, we will see the patenting criteria, filing procedures. Um, Probably people are not very much aware about such procedures. So we'll see how to make it a little more easy. Like we're a little intimidated when it comes to filing a patent application, and it's like no patent तो ऐसे होता है like only some category of people file for a patent application, so that kind of hesitation is there. Everyone, a lot of people do a research, higher studies, their projects. That is a part of academics. That is must during your academics. But very few people think that yes, along with that, I'm doing something. I am my major part of my education, 2-3 years of my education and my time I spent for my studies, and very few people think that I could get a patent also out of that, or I should do a patent application for the work I have done. So this thought is not a very common thought. Like people doing research will certainly publish their publication, because publication is like something must for during your research and all. By the end of your research, if you will be having some publication. So this thing publication people think of, but patenting is not that and easily approaching like uh, people are not that welcome. In this session we'll see how to make it a little more easy, and that hesitation can be overcome. I'll share my presentation. Please let me know whether you are able to see that. Is it visible? Visible?
Yes, ma'am.
Okay, my voice is not breaking, right? But I feel
It's clear. It's clear.
yeah. So this is an introduction to IPR, and an introductory part also. Along with that, we'll see the patent filing procedures. As the introductory part already told, that I'm Parvathy, Assistant Controller of Patents and Designs. We are in our patent office is in Mumbai. I'm working in Mumbai patent office in Sion. It is in Andop Hill to Sion. If you are interested in filing your patent application, or you want to get information regarding that, then you can come and ask also. You can contact us through emails also. So intellectual property rights. First of all, what is an intellectual property when it comes to intellectual property rights? Intellectual property means something in anything that is a creation of a human intellect, a creation of human mind can be called as an intellectual property. So anything that you see around which is created, you feel that is created by human, is a intellectual property. Pencil, mobile, laptops, electronic devices, all such things which are a creation of human intellect can be called as intellectual property. So this intellectual property, if someone creates something, they put their effort, they put their intellect, they put their intellect into that, and that results in a particular creation, that results in a product or something which is not there before. So these intellectual property rights are there to protect such creations, protect the creations of human intellect. It's like people are having like normal property is there, and this intellectual property is something different, that which creates out of my intellect, your human intellect. can be called as intellectual property rights. The major intellectual property rights we are going to see here is patents, designs, trademarks, geographical indications, and copyrights. These are the major intellectual property rights. As an introduction, I'll tell you overview of all these intellectual property rights. Patents are granted to inventions. That we know, patents are granted to inventions, any new creation of a product, or any new technology, any new process making a product. So such things are inventions. Inventions. So inventions are protected by patents. Again, then there is another category of intellectual property right, designs. Designs, invention में features of the product is most important when it comes to the invention or patenting, like technical features of a product which makes it different from the other product or the similar product in the market. Designs में it is like the outlook of the product, how it looks. Different designs की pens, pencils आते हैं, like different automobile vehicles with different designs come. So it is how it looks. The attractive feature is what important in designs. And trademarks. Trademarks, the term itself means it is an identity. It is a it can be logo. Simply we can say we can logo. आप लोगों को पता है कि logo, like we are very familiar with the branded products and all, and we identify that product with their logo, with the symbol of identification. That yellow the M signal of McDonald's is a logo. It's a trademark. So we identify their products with their logo. Every product, every electronic device, any designs, garments, so they put their logo so that the product is identified using that logo, so that that can be registered as trademarks. Geographical indications is an indication of a particular geographical community. वो भी कोई product हो सकता है कि like West Bengal के रसगुल्ले, Mahabaleshwar strawberry. So these are like indication of a particular place. So that these geographical indications, even Maharashtra के geographical indications काफी है, like Mali painting. So these represents a cultural identity or a identity of a particular society, and this product has a particular quality because of that particular society or particular place. Then copyrights में जो है literary artistic work like books, novels, music, and publications, journals, literature. So such and even soft computer programs are also protected under copyright. So these are the main intellectual property rights which are which people seek protection for. So in this session, we'll discuss about the patents and their procedure. It will give an overview of intellectual property rights. So if the first image, if you look, it is a laptop. The laptop there in a single product, we can see there is different IP we can get protected. The logo of Apple is protected under trademark. The technical features of the laptop is protected by patents. And the design of the laptop. Laptop comes in different designs. Some are extremely good, some are less high, some are easy to carry. So like the design of the laptop can be protected. Right? The manual of this laptop can be protected by copyrights because it is a written document. And integrated circuits. Electronic devices having different integrated circuit. Like a Samsung phone will be having a different circuit compared to a Oppo phone. So there, that integrated circuit layout can be protected by semiconductor integrated circuit layout design by registering that. So different IPs, different IPRs in a single product. So this slide I kept to just to have an understanding regarding the different IPs that can be protected. Yeah. So first is patents. So we are discussing about patents in this. Can anyone guess the first image in the slide? Yes, it is a patent.
Light bulb.
Yeah, electric bulb by Thomas Alva Edison. It was patented in 1880. So this is a drawing from his patent specification. I just put the second is from the television patent by J.L. Bird, and the third picture you all know. It's the पिक्चर ही थोड़ा टेढ़ा है, वो इसकी स्पेसिफिकेशन में ही वैसे ही पिक्चर था कि वो हार्ली डेविडसन के मोटर बाइक का पेटेंट है. So from this picture I'm telling you, like you can patent this vehicle as a whole. पेटेंट हो सकता है कि व्हीकल एज अ होल, हार्ली डेविडसन की मोटर बाइक के होल पेटेंट भी हो सकता है, एंड दे हैव पेटेंट्स फॉर ईच एंड एवरी पार्ट ऑफ दिस पर्टिकुलर व्हीकल. Even the exhaust engine, every single part, whenever they come with a modification, of course unki bike mein bhi kafi modification by time they make. So every time they come up with a modification, they file a patent application for that, and they try to get their rights protected. So these are some of the examples that I put just to bring into the mind how the innovations come. If you look into that evolution happened in the communication, telephonic communication, like the telephones changed over time. Every such phone came into the market is a separate invention. It's not like telephone ka ek hi patent. It has to come up with a modification or a further improvement of what was there before. It's a matter of a patentable invention. So from this picture, I just wanted you to get an idea that any further modification, आज जो टेक्नोलॉजी है उसमें से थोड़ा भी अलग कुछ आ गया तो वो उसका भी पेटेंट फाइल होता है. Like that also need protection, because if you don't protect, someone else will copy that, and you cannot stop others from doing that. आपके efforts, आपके time, उसमें जो effort लगता है, that someone else will do it in a very easy way, because someone has already put the effort and someone has already made something out of that. उसको copy करना इतना difficult नहीं है. It will not take that much time and effort. In order to avoid such things, people file patents. So first picture आपको पता है. Who's that?
Michael Jackson.
Michael Jackson can actually lean this is something very special about his dance, and that it is because of a technical feature in his shoes. He had a patent for that anti-gravity illusion shoes he had made, which helped him to lean about 45 degrees Celsius forward without bending his spine. So this is also a product. So he made that, or he came up with that idea into a product, and he tried to get a patent for that. It was patent at that time, so that no one else will copy that without his permission. So there is a problem in this slide. So in this case, so what a patent is like, a patent is granted to inventions. Inventions, like, it can be product or process. As an AG product, process patentable. So invention can be granted to a product or a process. In that, if you come up with patent helps a person to exclude others. I am an inventor. I came up with an invention, and I put my effort, I put my time, and all my skills to develop a product. And I am not aware. I'm not aware of the patents. So, of course, that I told you, someone else may try to copy it. If my product is a hit, of course, someone else will try to copy it. And he can commercialize the product in a cheaper rate because he did not put any effort in that. He can put it in a cheaper rate also. In order to stop that, we have to protect the creations by the inventor. So we come up with a so the inventor can file a patent application for that. Inventor get his protection. So inventor gets a protection. Inventor can exclude others. Inventor can exclude others from making use of his invention, and he can also commercialize. He can make money. He get incentives. He can license also. He'll get royalty. So that is the like why should I patent my invention? Because it protects my innovation and it gives me the monopoly. It gives me the exclusive right to stop others from doing that. Please wait. See, this was not like that, and there is some problem with my slides over. I was not able to present that in the other way, so I shared it with the Google Drive and then. Anyways, I'll tell you the thing. For a common person who's a student or someone who is doing a research, when will he think of a patent? Of course, mostly I told you people will think of publications. Public paper published by main intent होता है, but when someone thinks actually ahead of that, will try to file patent application. Why? It is a matter of pride for the inventor. उनके academics में भी इसका value
अगर
हो
तू
जाता है.
पाइथन का सिलेबस खोल के देखेगा ना, हाँ,
Okay, so it is a part of academics. It is a pride of a common man. Oh yes, I have a patent. I am a patent owner. तो वो pride होता है. But for a businessman, commercial aspect में patent का बहुत value होता है. लेकिन for a businessman, I can earn and invest out of this patent. उनकी brand value बढ़ जाता है. It patents decide his sustainability in that area, and he can also, if with a patent, he can go ahead of his competitor. Okay, so that is the value of a patent. Why the patent is so important that for different category of people, the value of patent is different. जो commercial scale में है, उनके लिए क्योंकि उनके investment के earnings की brand value की बात है. And for those who are in like a common researcher, it is like a matter of pride and it is a part of academic. So patents, जैसे मैंने बोला है कि patents are granted to inventions. Inventions है products or process of making a product. प्रोडक्ट को कुछ लोगों का ऐसा assumption है कि सिर्फ एक प्रोडक्ट लेके आए और वो प्रोडक्ट को ही पेटेंट मिलता है. ऐसा नहीं है कि उसके बनाने का प्रोसेस को भी पेटेंट मिलता है. So the products can be machine, apparatus, medicines, electronic devices. जैसे आपके surroundings में जो भी electronic devices और like even chairs में भी patents आता है कि modification, make it more comfortable.
पीछे बार जब बात हुई
like kind of additional features कि उसमें भी every human creation like invention or a product is patentable. The combination of product, food recipes patent होता है, and food items like जो भी chocolates, kind of confectionaries, candies जो market में आता है, Kinder Joy, so such kind of all the branded value food items, they also get patents. So it is an exclusive right. You can expect that exclusive right granted by the government to the patentee. So it is an exclusive right granted by the government to the patentee. Patentee means ek on a patentee. Like when you file a patent application, you are an applicant. But when you get a patent, like you got your patent registered, your patent certificate, you got your patent certificate, then you are a patentee. जिसको पेटेंट मिलता है उनको पेटेंटी बोलता है. So आपको पेटेंट मिलने से आपको क्या मिलता है? Like what is the benefit that you get out of getting a patent? You can make the product. Of course, I have an invention. I got a patent for that. I can make the product. I can sell the product. I can import the product also, and also I can license it. I'm a researcher. I got a patent. I filed for a patent and I got a patent and I really want to commercialize it, but I'm not in commercialization. तो मुझे इतना तो नहीं पता है commercialization में क्या करना, because there is a lot of things involved in commercialization, right? So in that case, you can find a company or or any person who can commercialize. You can give the license. In turn, you will get the royalty. The inventor or the patentee will get the royalty for the commercialization. So I can license it. If I get a patent, I have the right to make, sell, and import the patented product. ऐसे ही बोलेंगे तो लाइसेंस के बारे में बोले थे, like ARM Holding is a company which makes semiconductor processors. They make that low energy semiconductors which can be which is used in mobiles, digital cameras, and all. So they have enormous number of patent applications. They have a lot of patents in their name, but they do not manufacture any of their semiconductor processors. They always license it to other companies, and there are so many big MNCs which got license from this ARM Holdings to manufacture the semiconductor processors. So like their value of that company comes only through that license. So much licensing they have. Like, it is not necessary that you need to commercialize and you need to make and sell the product. If you are not interested, then you can license it to a person who can do that. So that is what a patent gives an inventor. And in turn, अगर inventor को patent मिल तो रहा है, in turn, inventor should disclose his invention to the public. You should give your complete disclosure. We are telling, आप अपना complete disclosure दे दो. You tell me how your invention is possible. How a normal person reading you about your invention or a patent application will be able to reproduce it. That is very important. Then only that will encourage others to come up with further invention. So there is a responsibility to the public also. Of course, inventor is getting a monopoly for his invention, that he has the right to make and sell his product. At the same time, he has the responsibility to give the public the information regarding the invention, so that he should fully disclose the invention. आप अपना full disclosure दे दो and get a patent. That is a so the patent term. एक बार अगर patent मिल गया, that these rights of the inventor is for 20 years. Date of filing of the patent application. Every year you have to renew this, but it is limited to 20 years. 20 years you have the monopoly. 20 साल तक आप उसको manufacture कर सकते हैं. You can import the product and you have the monopoly or you have the right to patent the invention. 20 साल तक का rights होता है. 20 साल के बाद, like पैरामोल के पेटेंट एक्सपायर हो गए, 20 साल के बाद any normal pharmacy can manufacture that drug without the permission of the inventor. So it's not required. 3 years के बाद वो public domain में है. Any public can make use of the invention without the permission of the inventor. Inventor can't stop anyone after 20. So the term of the patent is for 20 years. 20 साल तक का monopoly. This slide, this is a pencil, right? This slide I kept to make you aware that कि like छोटे-छोटे modifications जो product में आता है, so every such modification the modified product is patentable. So to just to make sure that make that principle clear. See, the first is a simple pencil. The second is a pencil with a grip. It has an added feature compared to the first one. Both can be a patentable subject matter. Can be like when it was initially launched. The third pencil with an eraser. It has again another advantage, like you don't need to look for an eraser while you are writing with a pencil. So pencil with an eraser. So when it first launched, it is again something which is different from which was there before, and it has an advantage over what was there before. Again, it is a different type of pencil with a particular features which was not there. Colored pencil. So these basically, when you look into these all, they are all pencils, but इनके features ऐसे है कि they are different products. They are like they fulfill the requirement of a different product in a patent application. Like मैंने बोला कि processes are also getting patented, like process of manufacturing a tea, process of manufacturing articles, medicines, vaccines, machines. People come up with eco-friendly processes like economically. E-vehicles and their parts, their advantage, low cost, more affordable kind of vehicles. So such like enormous kind of patent applications come out of a single invention. If I simply tell about a COVID vaccine के 100 से ज़्यादा patent applications file कर सकते हैं, because like if someone comes up with a particular vaccine, उसमें कोई booster की ज़रूरत नहीं है. Some other come up with like it is a stable one. You don't need to carry it in a nice box. It is stable at normal temperature. And some come up with a COVID vaccine which is associated with less side effects, like more affordable kind of vaccines. So this, like in a single product, if you look into a single product and multiple patents applications can be filed in, like people come up with the different patent applications of a single product, multiple variations. आपके पास एक patent है, like you feel that I have done something work patentable, I have done my research, and you feel that you need to get a patent for that. तो उसके कुछ criterias होता है. Main criterias that we check in a patent application is first is novelty. It should be new. It should be something new which was not there before. We conduct patentability search, और आप भी कर सकते हैं कि आपको लगता है कि आपकी जो work है आपको patent करना है, so you can also search in patent website, non-patent website, Google में. There are different databases for that. आप में search करके you can confirm that yes, my product with this particular feature or this particular advantage is not there before. So it should be new. The first criteria is novelty. Novelty means new, and it should not be obvious. It is non-obvious. Like a non-obvious, like it is new, but if I come with a drug, I'm combining two drugs, one for reducing the fever and the other for reducing headache. If someone else come up with a drug which is a combination of these two drugs, and he is telling my drug will reduce the fever also, मेरे medicine खाने से headache भी कम हो जाएगा. So it is a kind of obviousness. You just mix the two things and it is just obvious. नॉन ऑब्वियसनेस का और इन्वेंटिव स्टेप बोलते हैं कि उसमें तो नॉवेल्टी क्राइटेरिया वी चेक एंड वी चेक इन्वेंटिव स्टेप. इन्वेंटिव स्टेप जो होता है, इट इज लाइक a technical advancement. It can be a cost effectiveness, like it can be made with a low cost. It can be a cost effective advantage over the prior art, or it can be any other technical advancement, something which is surprising or technically advanced over what was there before. So that it should not be obvious, and it should be novel, new. And the third criteria is industrial applicability. Industrial applicability जो है mostly when the patent applications comes, जैसे मैंने देखा है कि industrially applicable होता है. Like there are very few. It can be made and used in an industry. That is the industrial applicability. All the inventions like when it is vaccines, drugs, or electronic devices, computer program per se is not patentable, but along with the software or a particular device, it is patentable. So such things are industrially applicable. So industrial applicability is almost there are very rare applications come without an industrial applicability. The first and the second criteria is most important. Novelty, it should be new and it should not be obvious. ये काफी dry topic है, so it may not be that interesting to listen also, but yeah, please cooperate. तो आपके पास एक आइडिया है, आपके पास एक पेटेंट, you feel that I need to file a patent application, then first thing you should do is you should search for patents, and you should also search in non-patent database also, but you should search for patents, and I'll tell you is where all the places you can see, you can search patent applications. First there is Google Patents. Google Patents में आप सर्च कर सकते हैं using keywords, और उसमें filters भी डाल सकते हैं. If you want to check patent applications of a particular company, if you put that over there, you will get the patent applications filed by them. You can see how they draft the patent application, how they file the patent application. Such things you can see in Google Patents. So Google Patents is it is user friendly, also very effective. I use this for search. And this is a patent database by Indian Patent Office. So you can see the trends in Indian filing. This will give you regarding the Indian patent application. So okay, so Indian patent application, you can file, you can see in INPAS, the database by Indian Patent Office. And there is a WIPO, like World Intellectual Property Organization. They have also a website called Patent Scope. World Intellectual Property Organization, who regulating authority hai, they provide courses also if you want to know about IPR and all. So it's a regulatory authority, and they have their own database or website. It's called Patent Scope. It is a search engine by European Patent Office. It is ESPAS. So in these places, if you search for patent applications, you will file patent. You'll be able to see patent applications. You can see how it is drafted, how it looks like, and all. So the next, so that is about patenting criteria. We told you it should be novel, it should not be obvious, and the third is industrial applicability. So if you feel that yes, my work fulfills this criteria and I should go for a patent filing procedure, so आप क्या करेंगे? So we'll see how the procedure is and what are all the fees required and the timelines we'll see in this session. A main part of a patent application, patent file करने के पहले, it is to everyone I'm telling you, this is the most important thing, that invention disclosure. मैंने पहले ही बोला है कि the inventor get a monopoly or patent when he discloses invention to the public, when he completely discloses invention to the public. So what a disclosure is, invention कैसे disclose करता है, so वो parts को बोलता है patent specification. Patent specification में आप सब कुछ, like every small details about your invention, you will list down in the patent specification. Then you will see, you will ask how a patent specification is like. What is a patent specification? Patent specification को different parts है. There are different parts. If you look into a patent specification, you can see a title of invention is there. You will give a title. Then you will tell the field of invention. Field of invention you can mention it in a 2-sentence or a 3-sentence, like in this in the field of medicinal devices, in the field of artificial intelligence. Even if it is a single sentence, it is okay. Field of invention. Then comes the background. Background क्या होता है? Background is like उसी field में आपके invention के just पहले तक आपके knowledge में क्या क्या है. So आपके इन्वेंशन आपने पहले ही सर्च करके रखा है कि आप उससे भी थोड़ा टेक्निकल एडवांटेज जिस है, थोड़ा टेक्निकली एडवांस्ड है. सो इट इज लाइक अ बैकग्राउंड. यू विल उसमें आप साइट रेफरेंस भी साइट कर सकते हैं. यू कैन मेंशन अदर पेटेंट एप्लीकेशंस इन द फील्ड. So that can be a few paragraphs. Sometimes it is like 2-3 pages. So it is up to you, and you make sure that you go through the background and you put the background in that way, like there is a flow. आप फील्ड के बारे में बता दिए कि it's a flow, like how you came to the invention. That is a background. In summary, again, in a on a paragraph or two, you will tell in general what the invention yours is and how it can be advantageous over what is there over the background art. नेक्स्ट इज ब्रीफ डिस्क्रिप्शन ऑफ ड्राइंग. पेटेंट स्पेसिफिकेशन में ड्राइंग्स भी अलग से देते हैं, तो वो ड्राइंग्स के पेजेस की ब्रीफ डिस्क्रिप्शन. ड्राइंग्स के जो पेजेस है उसमें ज्यादा टेक्स्ट नहीं होता है. Like you will just mention the drawing, you will just mark that points, or if it is a graph, you will just show the graph and will mention it as figure 1. And उसका description, वो उससे related further information, उसके description you will provide in the specification part, a brief description of drawings, and then detailed description. Detailed description, you will write everything. You will define every single terms. If there is mathematical calculations in between, if there is other method, how a person can perform this. So every details you will put in detailed description. Then there is an abstract. It is a kind of synopsis, as a small abstract, a single paragraph, a brief. And the other very important part is claims. What you are trying to get a patent for. So that is claims. Claim part is very very important. And since आप लोग सब technological side में है, तो drawings को बहुत importance है. Drawings helps to understand the invention more easily. So drawings सारे dimensions के drawings देते हैं. I'll just show you a specification. I'll just show you a specification. You can see this, right? Hello?
Yes,
Yes,
ma'am.
madam. Yes.
So I'll just show you. I just went through the impasse and took a specification just to show that how it looks like. So specification की form जो है form 2 होता है, उसको form 2 बोलते हैं. Form 1 we'll discuss, we'll see it later. So it is form 2. The front page of specification look like this. There will be title of invention. You will mention it as a complete specification if it is a complete specification, and the name of the applicant will be there. It is a specification filed by IIT Madras. So the address, and there will be like small preamble which shows the following specification particularly described. So this thing will be there. So this is the first page of the specification. So I told you there are different parts of specifications. The first is field of invention, where you tell, then you will tell about your invention is a background. Background, you'll give reference. It can be a small one. Object of invention, and these things differs actually in some cases, but make sure that you have such headings which give a briefing about your invention. Background should be there, field of invention should be there, the summary of invention. What your invention is, you will summarize in the next part. Summary can also be very brief summary. Then see brief description of drawings. They have provided some drawings in their specification, and they will briefly describe their drawings one by one like this. You can put the paragraph numbers on the sides. Then comes the detailed description. Detailed description is like you will describe every single part. Like if you see, there is actually a lot of things which is defined in this specification. Even if it is not this descriptive, आपकी जो इन्वेंशन में जो जो छोटे छोटे फीचर्स है उसको लाइक इधर आप इन्होंने बताया कि फोटो कैटलिस्ट इंक्लूडिंग ये कैटलिस्ट लीचिंग लाइक टेक्निकल फीचर्स जो बोल रहे हो, लीच रेसिस्टेंट फोटो कैटलिस्ट, ट्राई टू डिफाइन एवरी सिंगल टर्म सो दैट वो बाद में पेटेंट प्रोसीजर में आपको कोई प्रॉब्लम ना हो जाए. So again, the description continues. He'll describe in every possible way their process or their product. It can be any in number of paragraphs. There is no problem if it is so big. Also, you can describe it. The only thing is why I am telling this to describe it in this elaborate way is like you cannot add things in the later stage of the patent prosecution. If the patent office is telling यारे आपने तो उसको define ही नहीं किया है, that features are not there in your specification. आप जो बोल रहे हैं कि आपकी advantage ये है, so at that stage it will be very difficult. You have no provision to add things beyond a particular limit. So when you file the patent specification, try to make it as descriptive as it can be. After the description, आप examples दे सकते हैं. Examples in the sense आपके experimental evidences, like आप जो description में बोला है उससे related examples, how the invention is working, उससे related working examples आप दे सकते हैं. उसकी result and discussions. So these part you are very familiar, like you do this in your work. So this example with along with the data, this information is very important. Like this only helps you to make it like advantages कि data के एक points काफी crucial हो जाता है during patent prosecution. So what all things that you feel, yes, it is important, and even आपको filing के time पे insignificant भी लगाओ, but you put that in your specification. If it is well and good, if you put a separate paragraph to tell the advantages of your disclosure over the prior art, it's good. If it is not there, okay. Then the last come is the claim part. ये पेटेंट जो ग्रांट होता है ना, ये क्लेम्स को होता है. लाइक क्लेम्स में जो भी डिफाइन किया उसी चीज को पेटेंट ग्रांट हो जाता है. तो क्लेम इज वेरी इंपॉर्टेंट. It can start with a preamble like I claim or we claim. Here they have applied for it. Don't look into the subject matter. I just picked a random application just to see how a specification look like. Actually, most of the people are not aware how a specification. बहुत बुरा लगता है कि जब पेटेंट हमारे पास आ जाता है और स्पेसिफिकेशन एक्चुअली इन्वेंशन है भी, कि हियरिंग के टाइम पे पता चल जाता है कि अरे है इसमें इन्वेंशन है, और स्पेसिफिकेशन में उतना कुछ लिखा ही नहीं है कि लाइक टू डिफाइन दैट थिंग्स. सो it feels really bad कि हम लोग भी थोड़ा helpless हो जाते हैं. So here it is like a process they have claimed for. They can keep a first claim, an independent claim बोलते हैं उसको, principal claim बोलते हैं, and other claims, process का claim जो है dependent भी बना सकते हैं. Like they have many dependent claims which is dependent on claim 2. So these are all process claims. So they have filed only process claims. They have filed only process in their application. बट ऐसा नहीं है, प्रोसेस प्रोडक्ट दोनों भी एक एप्लीकेशन में फाइल कर सकते हैं. और बट प्रोसेस प्रोडक्ट का ना क्लेम्स अलग अलग होगा. कि यहाँ देखो एक they started with a process of synthesis, and if you have a product, it is like a product or an article or any preamble that you feel suits for that product, so that can be used. Like product or a process can be a part of the claims. आपको product का भी पेटेंट मिलता है, प्रोसेस का भी पेटेंट मिलता है, प्रोडक्ट प्रोसेस टुगेदर भी पेटेंट मिलता है. कभी कभी ऐसे लगता है कि काफी सारे प्रोसेसेस क्लेम में आ जाता है, तो ऐसे लगता है कि काफी इन्वेंशंस है. सो हमको भी लगता है कि अरे इसमें 2-3 इन्वेंशन है, ये प्रोसेस, ये अलग अलग प्रोसेसेस के लिए कि मुझे अलग अलग सर्च भी करना पड़ेगा. देन यू कैन फाइल अ डिविजनल एप्लीकेशन ऑल्सो. ऑफिस विल टेल दैट देन यू कैन फाइल अ डिविजनल एप्लीकेशन ऑल्सो. आपको 2-2 पेटेंट फिर मिल जाएगा थ्रू आउट द प्रोसेसिंग. So this is a complete specification. So I just share the complete specification because it will be useful. Yeah, we're moving back to our So that is how a complete specification look like. So make it elaborate and put as much as information that you can. So there are two kinds of specification. It can be a provisional specification or a complete specification. Provisional क्या होता है? आप research start किए हैं, आपको एक idea है, and you are having some results, but आपके उतना पूरा नहीं हुआ है. So like you feel like कुछ और experiments करना है कि to reach a final conclusion. So that time, if you are in an early stage of research and you feel that आपकी प्रायोरिटी, आपकी डेट बहुत इंपॉर्टेंट है, आप जो डेट में फाइल होता है, बिकॉज उसकी डेट के जिस पहले के दिन तक का सर्च होता है पेटेंट सर्च, तो उसकी डेट एक दिन पहले भी कुछ पब्लिश हो गया तो आपकी पेटेंट के लिए वो डेट्रीमेंटल हो सकता है. सो दैट डेट इज वेरी इंपॉर्टेंट. सो एज अर्ली you file a patent application, the less will be like citations prior that may be detrimental to your patent application. So provisional file कर सकते हैं आप, एक provisional specification with some briefing details, but still having almost all the information प्रोविजनल भी काफी एलोबरेट करके फाइल सकते हैं, बट इफ यू वांट टू ऐड एक्सपेरिमेंटल डेटा एंड ऑल, यू कैन फाइल इट इन द लेटर स्टेज. सो यू कैन फाइल ए प्रोविजनल स्पेसिफिकेशन. आपने प्रोविजनल फाइल कर दिया, सो यू हैव 1 year टाइम फ्रॉम द टाइम टू फाइल अ कंप्लीट स्पेसिफिकेशन. सो आपको 1 साल का टाइम मिल जाएगा. 1 year टाइम यू विल गेट. तो उतने में आपको अपनी एक्सपेरिमेंट complete करके you can file a complete specification by 1 year. So 12 months time patent office give after filing a provisional specification to file a complete specification. So 12 months के बाद नहीं accept होता है. So you should file it before 12 months. Like 1st January 2020 को आपने file किया provisional. So 1st January 2021 के पहले आपकी complete आना चाहिए. People really take advantage of this. That is really good for those who want to protect their research. So provision, we know that आपको patent specification is the most important, and you have seen the patent specification, right? So there are certain forms also. A patent document क्या होता है? It is a techno-legal document. इसमें technical भी है, of course technical information ही है patent specification में, and legal formalities भी है. Because of that, I think legal formality इसलिए थोड़ा hesitation आ जाता है. Technicalities paper publication में सिर्फ technicalities है तो सब publish कर लेते हैं. इतना भी है नहीं. Legalities you can also do that. There are certain forms that you require to file during the patent filing. So form 1 जो है उसमें आपके basic details देता है. I'll show you a sample form 1. Form 2 हम लोगों ने देखा, it is a complete or a provisional specification. Form 3 है. Form 3 में अगर आपके आप patent rights, one of the most important thing is patent rights are territorial rights. आपको patent मिला for this pen in India. Indian Patent Office ने आपको patent grant कर दिया, so you have that rights of make, sell and licensing in India only. You cannot do that in US. So to get the rights in US, you have to file a patent application and get your rights. So there is no worldwide patent. Indian worldwide patent as a provision नहीं है. You have to file patents in every jurisdiction. There is certain routes also that make this thing very easy. So territorial rights होता है. So if you file any foreign application, you have to provide the details in form 3. Then form 5 जो होता है declaration as to inventorship होता है. Like मैंने आपको बोला है कि पेटेंट में एप्लीकेंट भी होता है, इन्वेंटर भी होता है. I have not told, right? I'll tell you these things. So declaration as to, we'll see the form, then we'll get the idea. And there is a request for examination. What is this request for examination? मैंने पेटेंट एप्लीकेशन तो फाइल कर दिया, मुझे पेटेंट ऑफिस से कोई कम्युनिकेशन नहीं आया. Make sure, be very careful, you have to file a request of examination. Unless you file a request of examination in form 18, your patent application will not be examined. It is a universal procedure. सारे patent office में procedure यही है, because इसका कोई significance भी, it has certain significances also. So you have to file a request for examination also for the patent application to be examined and proceeded for patent. I'll show you the sample documents, that you will get an idea how the documents look like. So this was our specification. This is for form 1, first form that we have told that it gives details regarding the basic details of the individual who has filed the patent application. So this is actually the form 1 which we download from. You can file the patent online. So whenever you try to file the patent application, the first form probably appear on your system is a form 1 where you give the basic details. So the first paragraph is applicant. You don't have to. The type of application. Type of application यहाँ ordinary लिखा है, convention है, PCT है. There are different type. Don't आप directly Indian, you are an Indian or you are an outsider. If you are filing a patent application in India, then it comes under the ordinary one. Convention जो होता है, Paris Convention के अंडर है, it will be like very complicated if I tell. Convention is like for if a person who is in US, he want to file a patent in India also, so he can take the priority from his US application and come to India. So anyways, ordinary होता है. अगर आपने पहले ही एक पेटेंट एप्लीकेशन फाइल कर दिया और उसकी डिवीजन फाइल कर रहा है, so it can be a divisional patent application. There are different. So it is like ordinary, you will take and the name of the applicant in full, nationality, residence, address. So these things you will fill. Category of applicant. ये क्या होता है category? Natural person and other than natural person. Supernatural नहीं है. Natural person is like ordinary individual. I am a researcher. I have done my work and I want to file a patent application. So I am a natural person. So I'll click natural person. If it is a startup, if it is like others में any other multinational companies or any other company, so they comes under the other than natural person. If it is an institute, like आपने आपके institute के through आपके institute file किया है, तो it is like other than natural person में आ जाता है. अभी applicant तो देखा, inventor भी है. So inventor, like I have done my research, तो मैं ही file करूँगी मेरे patent application. So I am the inventor, right? But sometimes there may be an agreement between me and my research institute. Institute funding करता है मेरे research का. So maybe there is an agreement like whatsoever invention comes out of my research, applicant will be the institute. तो उस case में ये जो applicant है मेरे institute होगा and inventor will be mine. So you have to provide the details of the inventor. Inventor can be one person, many person, like 5, 6 inventors हो सकता है. Applicant भी हो सकता है कि 1, 2, 3, 4, 5 applicants हो सकता है. Like कभी-कभी 5 लोगों ने मिलकर research किया है, तो 5 लोग inventors है, तो उतना ही 5 लोग applicant भी हो सकता है. So in that case, applicant and the inventors are the same. And when you get a patent, you will get an equal and undivided right. Each inventor has the same right over the patent. ऐसा नहीं है कि first inventor को ज़्यादा right है, ऐसा नहीं है. Each inventor has the same right. So equal and undivided right. Inventor नहीं, applicant को rights मिलता है. Like inventor will assign the rights to the applicant तब. So inventor ही applicant है तो each inventor has the same right. If you are filing your patent application through a registered patent agent are people who are expertise in drafting the specification and their prosecution. So उनसे file कर रहे, you can also file. It is not mandatory that you should come up with a registered patent agent. You can also file by yourself, but they can help you. You have to charge their fees. उनकी fees होता है कि they can help you in filing. And ये सब 8, 9, 10 है आपके it depends on you, like what kind of application is yours. आपके ordinary application है, so you don't need to fill all these forms. Then come the paragraph 12 is the declaration. This is very important. As long as inventor जो है, inventor मैं हूँ और मेरे institute applicant है. When as long as I don't give the rights to my institute, he cannot be the applicant of my application. So here the inventor can give the rights to the applicant. यहाँ inventor का sign होगा, उसको proof of right बोलते हैं. So inventor gives its rights to the applicant. So these are the main parts. यहाँ declaration है. ये declaration पढ़ने के बाद आपको जो भी applicable लगता है, you can tick that. You can cut the other declarations. And most importantly, we check that applicant inventor category and the rights, whether inventor ने right दिया है कि नहीं, वो बहुत important है. जब तक inventor का right applicant को नहीं मिलेगा, applicant is not the authorized patent person to file the application. So this is form 1. आपको ये दिखा दूंगी. See, it's a demo form 1. Like here, it is an ordinary application. IIT Madras ने directly Indian Patent Office में file किया हुआ ordinary application है, and the applicant is IIT Madras. Their address is provided. They are other than natural person, कि individual नहीं है, because it is an institute. उन्होंने small entity पे टिक किया है. Inventors of course IIT Madras applicant है, तो inventors will be different from the applicant. So there are these are the 2 inventors they have mentioned. They have mentioned their title of invention, their address, and they have striked out these things which are not applicable to them. इसमें इन्होंने अभी तक सिग्नेचर नहीं दिया है इन्वेंटर्स को सिग्नेचर, ये जो प्रूफ ऑफ राइट बोलते हैं वो देने के लिए आपके एप्लीकेशन फाइल करने के बाद 6 मंथ्स तक आपको टाइम है. विद इन 6 मंथ्स आप कभी भी ये जो डिक्लेरेशन है इन्वेंटर का एप्लीकेंट्स को राइट देने वाला, दैट यू कैन गिव. सो दैट इज बट वेरी इंपॉर्टेंट. बिफोर द ग्रांट ऑफ पेटेंट यू शुड फाइल दिस, अदरवाइज द पेटेंट विल नॉट बी ग्रांटेड टू द एप्लीकेंट. So this is very important. So this is the declaration. You have 6 months time from the date of filing of the application. अगर 6 months में भी नहीं दे पाए तो आप बाद में भी फाइल कर सकते हैं, बट आपको petition और फाइन लगेगा. Normal time है 6 months from the date of filing. And they have picked some of the declaration that they. So this is their application. Form 1, Form 2 हम लोगों ने पहले भी देखा उनका. Form 3, अगर if you have filed any foreign application, so this is Form 3. इसमें they have striked out like they have not filed any patent application outside. उन्होंने बस इंडिया में ही फाइल किया है. फिर है कि एक डिक्लेरेशन बाय एप्लीकेंट भी डिक्लेरेशन देता है, वो Form 5 में होता है. So these are the mandatory forms. इसमें क्या है, like this is my invention and they are the inventors. So this is a declaration by the applicant. So these also you have to file when you come up with your patent application. So these are some of the major requirements. If you keep these things in your mind, the patent filing is not very difficult. Moving back to our presentation, you'll see the fees. Fees जो है, नेचुरल पर्सन है, स्टार्टअप है, स्मॉल एंटिटी है, एजुकेशनल इंस्टीट्यूशन है, तो फीस 1600 है, along with the filing of the application. I told you आप फॉर्म 18 में रिक्वेस्ट फॉर एग्जामिनेशन जब तक फाइल नहीं करेंगे, up to that time your patent application will not be examined. So form 18 also requires fees. 4000 है for a natural person or a educational institution. आपकी educational institution भी फाइल कर सकते हैं. So स्पेसिफिकेशन की पेजेस अगर बहुत ज्यादा है, so एडिशनल पेजेस 30 से ज्यादा पेजेस है, तो यू हैव टू पे एक्स्ट्रा फीस फॉर दैट. यू कैन फाइल दिस. एक प्रोविजन है एक्सपेडाइट एग्जामिनेशन का. नॉर्मली एग्जामिनेशन, दिस आई विल कम बैक टू दिस स्लाइड. सो फाइलिंग प्रोसीजर इज you can file it online also. You can file the hard copy in the patent office also. Online filing के लिए digital signature may be needed, that you have to procure, or if you are filing through an agent, they will be having the digital signature. So you can go through the website. IP India website will provide you the details regarding the patent filing. पेटेंट के प्रोसीजर, सो हम लोग ऑर्डिनरी एप्लीकेशन का ही देखेंगे. आपने प्रोविजनल फाइल किया फॉर एग्जाम्पल, तो वन ईयर यू विल गेट टाइम टू फाइल अ कंप्लीट स्पेसिफिकेशन. आपके स्पेसिफिकेशन फाइलिंग होने के बाद 18 months, with 18 months time it will take for publication. It is also a universal time. Publication में 18 month time लिखता है. When it is published, if you file a request of examination, then it will be examined और आपको first examination report मिलेंगे. उसमें कुछ objections होंगे. No need to get worried that you got a first examination report negative. You can give your submission within 6 months. And again, आपके submissions को फिर से verify करके, you may get a hearing with the controller. There you can explain, maybe through video conference or sometimes physical hearing is also provided. अभी ये कोविड के टाइम पे mostly video conference से ही hearing होता है. So उसके बाद patent will be granted. आपको एक certificate आपके email पे भेजा जाएगा. So that is the processing of a patent application. So patent application की ये वो जो 18 month publication है, आपको जल्दी publish करना है. You want an early publication, you can make a request for early publication in Form 9. So Form 9 में आप request डालेंगे तो उसके next month generally publish होता है आपकी application. So you don't need to wait long for your publication. And आप Form 18 जो request of examination आप application file करने के साथ भी डाल सकते हैं, और you have enough time to file a Form 18. 4 years तक का time होता है to file a Form 18. That is also a general, a universal timeline for Form 18. So request of examination, you can file it along with, but Form 18 का date बहुत important होता है. So that is the date used for examination. ये है basic timelines. Provisional to complete we discussed, right? 12 months. Request for examination form 18 के लिए 48 months का time है. आपको first examination report मिल गया, FERS first examination report. Then you have 6 months time. Form 3, like every 3 months, आपके foreign में कहीं patent application filed है, so every 6 months you can file, update that. Form 5 you can file. If you want to withdraw, आपने file कर दिया and you are like no, उसका दूसरा भी patent है, I don't want to spend my money in this patent application, then you can withdraw your patent application within 15 months. So yeah, oppositions भी कभी-कभी होता है, like I filed a patent application and someone feels that yes, no, he is not the right inventor, then they can oppose that. So such things also happen. This is a general outline of our patent office, like not only patent office, intellectual property office का राजीव गांधी इंस्टीट्यूट ऑफ इंटेलेक्चुअल प्रॉपर्टी एंड मैनेजमेंट RGNIPM नागपुर में है. They provide intellectual property related courses, so you will get more idea about if you do such online courses and all. They provide courses and training for the people. Patent office है मुंबई में है, कलकत्ता, दिल्ली and Chennai. Since your institute is in Maharashtra, you can file it in Mumbai, and it is up to the jurisdiction. जो साउथ में है, they can file in Chennai. Design office in Calcutta, and trademark registry Mumbai, Delhi, Calcutta, Chennai, and Ahmedabad. And in all these cases, you can file it online as well. Geographical indications का registry है चेन्नई में. Semiconductor integrated circuit layout design चेन्नई में, and copyright registry is in Delhi. So that is regarding. I have not told about the expedite applications. Like 48 months मैंने बोला है कि RQ फाइल कर रिक्वेस्ट फॉर एग्जामिनेशन के टाइम है, बट रिक्वेस्ट फॉर एग्जामिनेशन के बाद एज पर द RQ एप्लीकेशंस एग्जामिन होता है. बट इफ यू वांट द एप्लीकेशन टू बी एग्जामिन्ड, आपको बहुत जल्दी है पेटेंट मिलने के लिए, देन इफ यू फॉल अंडर एनी ऑफ दिस क्राइटेरिया, देन यू कैन फाइल अ एक्सपेडाइट एग्जामिनेशन रिक्वेस्ट. एक्सपेडाइट रिक्वेस्ट जो है मोस्टली फीमेल in applicant hai. If she is alone or if she is with other natural person, then she is eligible for that application is eligible for a expedite request. For small entities, startups, government funded institutions, there are different categories of organizations, or if they take for that international search authority. India is also an international search authority. If you want a search opinion and you took international search authority to file your patent application, then that also you can file a expedite request. So that is one thing you can take advantage of. Expedite request is a good option. Mostly people don't want to wait for patenting procedures, long procedures, so expedite लेते हैं and काफी जल्दी process हो जाता है patent. Within 6 months का time लेता है. 6 months is minimum time. 6 to 7 months में patents होता है grant. Sometimes it takes 1 year maximum. So that's it. I don't know. It was I already told it was a dry topic, and since it is related to the procedure and filing, that is why. If it was including that trademark, copyrights, geographical indications, then there will be some pictures and videos also that I can show. In this, I can show only this. What is the difference between patent, copyrights, and trademark? Okay, patents, I told you, right? Patents are granted to inventions, products को देता है, technical features you have to disclose. Patent का specification काफी long हो जाता है. It is not like that in trademarks. Trademarks में if I show you, I have this bicillary, even bicillary ki the way of writing bicillary is their trademark. So these kind of identification, like ISA is a certification mark बोलता है. So this can also be any such identity or logo which is used in commerce can be called as a can be registered through trademarks. Trademarks के अगर example बोलेंगे, like Adidas के logo, trade logo, everyone knows. So you will identify the product of Adidas के shoes. You will identify using that particular logo. So that is identity that trademark gives. अगर आपने register नहीं किया है, Adidas is a registered trademark of course, but still Adidas की जो scope और उनकी goodwill market value इतना ज़्यादा है कि people try to make duplicates out of that. Adibas आता है, such things are very common, right? So if it is a registered trademark, Adidas registered trademark है, they can stop people from doing such things. अब वो जो कंपनी के गुडविल के अगेंस्ट जो भी प्रैक्टिसेस होता है, मैल प्रैक्टिसेस को they can stop that. So that is the main advantage that gives with the trademarks registration. Patents प्रोडक्ट और उनकी फीचर्स को ग्रांट होता है, इन्वेंशंस को ग्रांट होता है. ट्रेडमार्क्स प्रोडक्ट की आइडेंटिटी और आइडेंटिफिकेशन ऑफ प्रोडक्ट के वो जो लोगो, सिंबल्स, स्लोगन्स, नाइकी का जो है टैगलाइन, जस्ट डू इट, सो दीज आर ऑल ट्रेडमार्क्स. लाइक इट कैन बी अ कॉम्बिनेशन, समटाइम्स देयर आर साउंड मार्क्स आल्सो. इंडल के जो एड में जो साउंड आता है, सो दैट इज अ साउंड मार्क. सो इट इज अ काइंड ऑफ आइडेंटिटी ऑफ अ प्रोडक्ट. फिर कॉपीराइट्स जो प्रोटेक्ट करता है कंप्यूटर रिलेटेड इन्वेंशंस में अगर बोलेंगे तो कंप्यूटर प्रोग्राम पर से, लाइक एल्गोरिथम हुआ, कुछ कंप्यूटर प्रोग्राम पर से इज नॉट कैन नॉट बी पेटेंटेड. अदरवाइज काफी सारे कंप्यूटर आर्टिफिशियल इंटेलिजेंस वगैरह में काफी सारे पेटेंट्स अभी ग्रांट होता है, like autonomous driving vehicles. Like if it is associated with a particular device, if it is associated with a particular software, then it can be considered as a like a technical solution देता है. वो computer program per se is not giving a technical solution. If it is associated with a product, then that can be patented. Like biometric का features patented होता है. Like lens card, I'm not telling any particular brand or something. People use such devices to test your eye features from a particular distance. So such features can be granted, patented. So copyrights is mostly. I'll open the chat, so I think it is more easy to. कॉपीराइट इज ग्रांटेड टू लिटरेरी आर्टिस्टिक वर्क. आपकी कॉपीराइट होता है, आपने एक म्यूजिक एल्बम बना दिया और आपको रजिस्टर करने की जरूरत नहीं है कॉपीराइट के लिए. इट इज मैंडेटरी, एक्विजिशन इज मैंडेटरी. if you are writing something, you can put that copyright sign with that C inside a circle, or you can write all rights reserved, or you can write copyrights, it is my copyright. And as long as you are using it for an educational purpose or an awareness purpose, it is okay. But if you are using it in a commercial forum, if you are using it in a social media and you are gaining commercial benefits out of that, such things are copyright violation. Copyright mostly artistic works का होता है, जो creator जो है उनको due recognition मिलना चाहिए. जो music, movies अगर like if someone is copying a movie, an Indian movie, and making it into another language, then that is a copyright violation. You have to get the due permission from a copyright owner before doing that. अगर नहीं करेंगे तो it can be legally very troublesome for after. So that is the difference. I hope I'll just. Is the patenting process same for plants or animals? Yeah, there are some things which are not patentable. सेक्शन 3 बोलता है कि इंडिया में कुछ चीजें पेटेंटेबल, इंडिया में नहीं कि like if you come up with a frivolous invention is not a workable, like a machine with more than 100% performance, like a machine which works continuously without an input of energy. So such things are impossible. Such things are not. If you come up with like that, not patentable. If you come up with an abstract idea, आपके पास बस idea या आपने कोई product develop नहीं किया है, so such things, abstract idea patentable नहीं होता है. प्लांट्स एनिमल्स के बारे में बोले तो प्लांट्स एनिमल्स और उनके पार्ट्स पेटेंटेबल नहीं होता है. इफ यू आर ट्राइंग टू मेक लाइक समथिंग व्हिच इज कॉन्ट्ररी टू द मोरालिटी, लाइक क्लोनिंग, ह्यूमंस को ही क्लोन करके बना रहे हैं, सो सच प्रोसेसेस और सच क्लोन्ड आर्टिकल्स आर नॉट पेटेंटेबल. माइक्रो ऑर्गेनिजम्स पेटेंटेबल होता है इफ इट इज लाइक some recombinant, लोग recombinant microorganisms बनाते हैं, so that things can be patented. कुछ है naturally occurring substances. आपने एक डिस्कवरी किया, mere discovery which was not there before, कि कुछ नया माइक्रो ऑर्गेनिज्म मैंने डिस्कवर किया है, इट इज अ नेचुरली occurring substance, और आपने अपनी बॉडी से कुछ प्रोटीन आइसोलेट, I'm extremely sorry. मेरे examples biotech के side से आते होंगे because I am handling inventions in the field of biotech. So ऐसे naturally occurring substances. So, the thing is that naturally occurring substances are not patentable. If you are performing a surgery or surgery related method of performing a surgery, method of a treatment, method of vaccination, so such method, vaccines patentable है, vaccines बनाने का method patentable है, but अब vaccinate कर रहे हैं किसी और को और वो method अगर patent करेंगे देखें तो it's not patentable, like a prophylactic method बोलते हैं, diagnostic methods. Computer program per se is not patentable. Awareness program is, yes sir. I think another 15-20 minutes. So computer program per se, mathematical methods is just an abstract mathematical formula, then it is not. If it is associated with like uske conclusion में एक technical problem का solution हो रहा है, then in that way it can be patented. But mathematical solution, mathematical methods like mathematical calculations per se आप new mathematical calculation लेके आए हैं, so per se it's not patentable. Then gaming methods are not patentable. Traditional knowledge, like हल्दी दूध में डाल के पीते हैं, ऐसे kind of traditional knowledge में या एक database है अपने पास, TKDL बोलते हैं, CSIR develop CSIR का, so there we search for traditional knowledge. So traditional knowledge as such is not patentable. There are so plants and animals के बारे में जिन्होंने भी पूछा है कि plants and animals नहीं patentable है, but if you are making a recombinant plant and उसकी method processes patentable है. Is the patenting process same for plants? Okay. If any object I want to patent has some components that are essential to the working of the object which have already been patented, then who owns the IPR of the object? Okay, so you have come up with an object, you have some components which is already there. Of course, like जो bike का मैंने motorbike का दिखाया, if it has an added feature which was not there before, like पेंसिल का मैंने एग्जाम्पल सिखाए थे, पेंसिल के बाकी फीचर्स वो जो इरेजर वाले पेंसिल में भी थे, इट वाज देयर राइट. सो एक्स्ट्रा फीचर जो है आई एडेड दैट इरेजर ऑन द बॉटम, at the bottom, so that added a particular advantage over the product. So वो technically थोड़ा better, you should be able to prove that upon adding my feature the product उसका value addition हो रहा है, like it is technically advanced over what is there before. So in that case of course you can come up with a, ऐसे ही patents वैसे ही बनता है. You can't imagine a particular product के those who are really, see ये जो patent hesitation है जो first timers और second timers के लिए होता है, after that you understood what all things are getting granted, then you will be like we can file a patent every single time you start your research and all. So improvisation is always welcome, as long as you have to tell that it is non-obvious and it is novel. Then who owns the IPR right? तो first product का IPR right उनको होंगे जिन्होंने the first product invent किया. So added improvised product का IPR right will be the person who improved the file, the improved one, the latest one. मोबाइल्स में भी अभी आर्टिफिशियल इंटेलिजेंस के कितने सारे प्रोडक्ट्स आते हैं, सो वन एवरी थिंग कम्स टू द मार्केट इज अ पेटेंटेड प्रोडक्ट, और एक ही प्रोडक्ट के अंदर मल्टीपल पेटेंट्स द कंपनी ऑन्स, दे वोंट स्किप एनी सिंगल फीचर. मैम नेक्स्ट.
I think all questions are over now. Those they were in the chat box. Almost all you have answered.
Yes, ma'am.
Idea for an app. Idea cannot be patented, that I have already told you. Apps, it depends. It is all drafting, but if it is a program per se, or if it is used in business methods, such methods are not patentable, or you can find protection through copyright also. it actually depends on how the app is, what the technical features is. If it is providing a technical solution for a technical problem, then it can be patented. Novel solution, but before I file a patent, I realize someone else has come up with a similar idea. Okay, just a few days ahead of us, they have made their idea public. Can we still file a patent if we have proof of dates that file? You can file a patent. See, this proof of evidence comes when there is a dispute in court. For a patent application, एक patent application file हुआ हमारे सामने, like, and you have filed a request of examination, we will be checking the inventions in that particular field. I told you, आपके filing के just एक दिन के पहले तक का date का, we put a filter, हम लोग filter वही डालते हैं कि आपके date of filing डालते हैं. So उसके उसी दिन के पहले जो भी पब्लिश हुआ है, that could be detriment for your patenting. So इसीलिए बोलता है कि आपके पास अगर आइडिया है, don't delay, प्रोविजनल फाइल कर दो, 1 year के टाइम पे कंप्लीट फाइल कर सकता है कि so that no one else will file a patent before that. So the date is very important. That is why people, those who are aware of this patenting and the procedure will file a patent application as soon as they come up with. Ma'am, if any object I want to patent has some components that are essential. No, we have read this. Okay, so is there anything? And I know it was a little dry topic. I am helpless. But see, patent applications, सबसे ज़्यादा internationally, if you see, China files the most number of patent applications. And China में filing देखोगे, and their filing mostly उनके Chinese ही रहता है. Like the people there only file their patent applications, and they are aware, they protect every single thing they come up with, they don't wait. So India, if you look into the Indian filing, only 40% or less than 40% ही Indian filing होता है. बाकी 60 plus filings जो है foreign companies के, foreign applicants से होता है. So that thing, if you also come up with your filings, your patent applications, you will get, there is a chance, there is a high chance to get a patent granted. Just thing is, you keep such things of complete disclosure. आप complete disclosure मत भूलना, तो वही main problem होता है, and proof of right. So like, if you keep these things in your mind, and if you feel that yes, I will not be able to draft a specification and filing and all, then you can get a help from a patent agent by paying them. But the chance of getting patent is high, so you can file your patent application.
Yeah, actually, I think you have answered all the questions. Thank you for your patience and answering each and every question going through chat box.
That's fine, because see, this is students are really people will not be interested. They are students, and अभी filing के बारे में भी बोलेंगे तो वो लोग सोचेंगे नहीं. But think, I just want to be like, just feed such things into their brain that ये बाद में जाके now may not be they are thinking that way. पेटेंट के बारे में वो लोग सोच भी नहीं रहे होंगे, but बाद में जाके they'll something will be there in their brain that ऐसे हुआ था.
Next, ma'am, it was really a very nice session, very informative session. You have literally shown us different forms, so which gave us a real feel how to fill a form for the patent, and it will definitely help our students. So on behalf of entire VESIT family, I would like to thank the team, your entire team. You are working under NIPAM. So thank you for giving us time and arranging this session for us. Along with this, I would like to thank your team member, Kuldeep sir, Nilesh sir, and Sagar sir. Those they helped us in arranging this session. So thank you very, very much for arranging this session for all of us. And on behalf of our entire VESIT family, we would like to thank our principal ma'am, Dr. Nair, and our vice principal madam, Dr. Vijayalakshmi madam, our managing trustee. Those they gave us opportunity to conduct this event for all our students. Special thanks to our IIC and IQAC team for their guidance. And last but not the least, all my students, those they are here to attend this event and making it a grand success. So thank you very much everyone for being over here. Feedback form link has been shared there in the chat box. Kindly fill your feedback. Once you will fill your feedback, we are going to submit this database to a patent office and you will be receiving your certificates from patent office. So thank you one and all. Ma'am, can we get your email ID in case any doubt we have in for future? Can we connect to you?
Yeah, you can log into your website also. Anyways, I'm providing your email ID. There in the chat box.
Yeah. Thank you.
Okay. Thank you, students, and I really appreciate your patience. I thought people will start leaving once they look into that
No.
procedure. And
Ma'am, we
It
should
Yeah,
thank
can
you
we
actually for
request like
patiently
everyone to switch on camera so that we can take
was
screenshots?
an excellent session, madam. Parvathy, madam.
thank you, sir, and I really thank you for. He was actually calling me and he was making sure that everything will be on time and there won't be any delay. And I really, and he only told me that you already had an awareness about that intellectual property basic rights, about copyrights and trademark, and of course, patenting procedure. If people are aware about, then it helps a lot in filing and all.
It was interactive,
Thank you,
very
sir.
good.
I
Nice
am really
session.
honored to be a part of this
It
event.
was covered at a length properly.
Yeah. Yash, please take screenshots.
So all are doing their online classes. Still not in college.
Yes. No, classes are online, but
Okay.
for few activities, they come to college. For project work and all, they can come.
That's great. Otherwise, it will be very difficult for teenagers to stay at home.
Yeah.
Time you
So thank you everyone. Thank you for joining. Please feel feedback which is shared in the chat box before leaving.